I spy with my little eye a prospective client that has been putting off estate planning. We often don't do what we need to do. We believe it's too difficult, too time-consuming, takes too much effort. It's daunting. We become overwhelmed with analysis paralysis. Think about what you have and where it needs to go, and how does that butt up against the laws of the land? So if you have assets in your name, if you have the stuff of life, a house, a retirement account, bank account, an annuity, a brokerage account, where do you want it to go in the event, the unlikely event that you pass away? It's unlikely now, but it's a certainty at some time until they get AI and gene splicing and quantum computing get together. Until then, we have to plan to the however unlikely circumstance that we're going to pass away. What do we do? Hit the things that we've accumulated during our life. How do we best set up our family so they don't fight each other, that it's the most convenient, the least time consuming, and the least cost to? We have to put an estate plan into place. One of the best methods is to use a plan that has present day force and effect, like a trust. A trust works for you during your life and it takes over after your death without having to go to court. Is that one size fits all? No, well, it fits your circumstance. It fits your life, just like anything else. Take time to plan. And I see you out there. I see you. I met with a client today, and it's going to be a real estate litigation. What happened was, at some point, the person that I'm going to represent was placed on a deed by his mother, and an aunt and an uncle that he had were also on the deed. Now, a mortgage was taken out, and the uncle says, I don't know what I signed. Something was handed to me, and I'm not sure. I had a client, story two. I had a client 2 weeks ago sign a revocable living trust and advance directives. They had attended a seminar. We met, we discussed it again in person, and then we signed 3 in-person meetings, actually signed, and a deed signed placing a property into the trust. Client reached out to me after 3 in-person meetings, signing the deed, signing the trust, saying, I don't really know what I signed. Can we go over it again? I said, sure. We set up another appointment. Speaking with an attorney colleague today, said that he did a deed for a family going from properties going from an individual name into a trust. Did the deed, they signed, went to record it. The county rejected the deed and said, this deed was already done. That family, months before, had done a deed with a different lawyer. They didn't realize what they signed. You have to have an awareness of what you're signing. It's unbelievable, but people don't realize what they're signing. Even with a lawyer, my own clients signed everything after 3 meetings, didn't understand it. And it's overwhelming. There's a lot to know. This other attorney did a deed. The family had done a deed months before. They didn't know what document they had signed. And the person that I had a consultation with today was a bar referral, so I feel a certain amount of clients or prospective clients as a community service, as a help to the bar association. And this person's uncle didn't know what was signed. So it's not unusual to not know what's signed. Take a look at it, go through the documents, write down questions, and then receive the answers and write down the answers. Because sometimes you can understand in the moment and then a few months later not know what you signed and don't realize the answers to your question. Be aware, be very aware. Years ago, Bono and U2 had a song, With or Without a Last Will and Testament. With or without your last will and testament. Might have been something like that. If you don't have a last will and testament and you don't have a trust, you may find yourself stuck with the laws of intestacy. Intestacy is the rules, the estate plan that the government puts on you. So if you don't have a will, but you have an asset in your name when you pass away, a single asset, a home in your name only, a bank account in your name only, a brokerage account in your name only, and you haven't taken steps, you need to administer that by a process called administration. So without a will, you have to go to the surrogate's court, and there's a few different reasons why you might go to surrogate's court. One of which is if you don't have a will and you don't have beneficiary designations. But why don't you call me and I'll go through your reasons with you. No will, intestacy, administration. Will, probate. Will is a probate. No will is an administration. Frank, Bruno, law.com.